SJC 12073, Francois Parker v. Enernoc Inc. and others.
Mr. Berluti, good morning.
Good morning, Chief Justice Gantz and justices of the Supreme Judicial Court. May it please the court. Retaliation damages should be trebled if they are for commissions that the employee would have earned but for the retaliatory discharge.
Before you go on too much further, would you tell me what your position is with respect to the Attorney General's brief? Do you agree with it?
I do.
Okay, so she says that it should be both lost wages under Section 50 for retaliatory damages as well as wages under 149, right?
That's right. That's right.
And you agree with that?
I do agree with that.
Okay.
The trial judge in this court unduly focused on what was due on the last day of employment and while an employee is still employed. I think those are phrases that the trial judge added to Section 150. The jury found that Ms. Parker's damages for retaliation was for commissions that, but for her wrongful termination, she would have been entitled to. They accrued 1 year after she had been terminated. The judge's focus on the last day of employment is not found anywhere in any of the statutory sections. The defendant, respectfully, is wrong that the statutory scheme set out in Chapter 149, Sections 148, 148A, and 150 does not contemplate treble damages for damages awarded for retaliatory discharge.
If we assume that the true-up policy was in effect when Ms. Parker was employed, Eaton would not have made the decision yet on the termination for convenience clause. So how is it that we can figure out what the commission is? How do you calculate it and whether it's due or payable? Don't you need to have Eaton decision have to be ripe first?
You do. That's exactly right, Justice Lowy. So the point is that the amounts were not due on the date of termination, but certainly by the date of the trial. That termination for convenience date had come and gone. Eaton had not exercised it. So this is akin to back wages, if you will, in the form of an anti-discrimination case.
I'm not sure I follow that. In order to get those commissions, right, she needed to be there at the time, right? She also, how would, say she kept working there, what were the requirements for her to get those commissions?
Simply that,
Even though they renegotiated the contract?
But the jury, that was a question for the jury.
Well, is it? I mean,
the jury
in order to get treble damages, right, you have to have earned them and be entitled to them. And they had to be both earned and due, right?
Well, that's the precise question that the trial court was dealing with. And his focus that they had to be earned and due on the last day of employment is what we submit is something he grafted onto the statutory section.
Well, they had to be earned and due. They weren't earned and due until when?
They were earned when she was terminated. They were earned when the contract was signed.
Is that true? They were earned, but they weren't accrued, right?
That's right. They were not due and payable. That's exactly right, Justice Kafka. The termination for convenience date had to come and go. But once that date came and went, those damages then became due and payable. This is not a case.
But again, more precisely in that case, though, they renegotiated the contract, right? They were unhappy. Enerco, whoever it was unhappy, right?
Well, do we know why it was unhappy?
Rogerio Branco, the assistant vice president for Eaton, testified in this case. And he said that but for the efforts of Fran Parker, this contract never would have been signed. Now, it's true that
I agree with that part of it,
yeah.
But it's the earned and due when they renegotiate the contracts after she's left. You know, it gets more complicated, right?
Well, it's a bit more, but this may be helpful under this fact pattern. The way that the contract was awarded, the negotiation phase, Ms. Parker brought it up to a certain point. At that point, the negotiations were completed by managers above her. So at the very last stages, she was not the one directly negotiating it anyway. So in that context, it really is no difference at all. The fact that there was some tweaking, really what they did was shorten the term a bit. And I'm not, there was no analysis, there was no evidence given as to all of the changes that were made. The biggest thing was that the time period was shortened a little bit. This was a question that was put to the jury, and the jury found that they were calculable once the termination for convenience date expired.
Well, the defendants have a different spin on the jury verdict, though.
Well, they have a different spin on a lot of things in this case. But
Well, I wanted
jury-
to ask you particularly about that, because that flows into exactly what the jury found. I think that as it relates to the JNOV, their analysis of the jury verdict as it relates to this, the true-up policy and the commission, is that was really a contract finding as opposed to a wage act finding.
Oh, well, that's because of their view that retaliation damages cannot be trebled and they're not wages, because they were not due and payable until post the retaliation date. So there's nothing in Section 150 that says that somehow culls out retaliation damages different than the litany of sections that are covered under 150 regarding damages. The jury specifically found in the jury verdict question, and it's question number 5, B, unpaid commissions due later under the true-up policy, and they found that to be the $350,000. They also found it to be a breach of the implied covenant of good faith and fair dealing. And that's the part about this that's inconsistent, that I respectfully submit the defendants have it wrong. For the court, this part of it feeds right into the Fortune and the Graham doctrine. If an employee signs a big contract, the employer, if this decision was allowed to stand, employers would have an incentive to terminate employees.
Well, okay, that's a good point. So if you can't fire somebody because they're going to have a termination, they're going to have a commission that's really going to be a lot of money, and they want to save the money. But isn't the issue really when the person leaves, can you calculate that amount at that point in time, and is it due and payable at that amount of time? Now, it's a whole different situation if the reason that it's not calculable or due and payable is because the employer says, I don't want to pay this commission, so let's terminate this person before it comes to fruition. That's a different story. But if it's a straight situation where the employee leaves and the commission's not due and payable and calculable, why would the damages be trebled and not just retaliatory?
The focus, I think, there, similar to the Israel versus Voya case, is what was reasonably anticipated. Don't forget, the only reason the employee was not in her seat in this case is because she was terminated, and the termination was found to be wrongful, unlawful, and retaliatory. So if the employer is taking the employee away from having that opportunity, then it's clearly damages that flow from retaliation.
But is it clearly treble damages? I understand Graham and retaliation, and you can't deprive someone of commissions, but there's the issue that Justice Salinger wrestled with was whether you get treble damages there, which is different, isn't it?
So that begs a good question, Justice Kafka, that if the termination for convenience date was to occur after the trial, and the jury was anticipating that she would earn them.
Do we really want to connect treble damages to how quickly we try a case? I mean,
Well, no, but you do want to connect it as to when the amounts are due. Why should the employee, and this is what the cases talk about in terms of the Israel versus Voya case, you'd be creating a perverse incentive to employers.
but don't we on we treble damages on Wage Act violations because we're really concerned about depriving people of money they earned. They earned that money already, and you took it. You never paid them. This is different, though. She she's terminated and she's suing over a payment that she may be entitled to prospectively. Isn't that different? It's
that was-
not, go ahead, sorry.
No, I'm sorry. That was one part of her damages. Obviously, they also found that she was shortchanged by $25,000 on the date of her
Not
termination.
quibbling with you
That's
on
separate.
that.
But what I'm saying is this, Justice Kafka, is that if all things had gone straight, and if the employer did not act unlawfully, she would have earned her commissions on or about April 1 of 2016. This case was tried in May of 2018. She was deprived of that income for some 18 months, and that's exactly what the wage and hour statutes, what the legislature intended by filing these. So for that reason, I think it is the same. It constitutes back wages.
Now, retaliation could include emotional distress damages as well, correct?
It could, Judge.
Okay,
Yes, Justice.
so if you are correct going forward, there would need to be a jury finding as to the allocation of damages between the retaliation damages that arise from lost wages and those that arise from emotional distress, correct?
That's correct, Justice Gantz. And I also think it should be for other consequential damages. For example, if an employee that was wrongfully terminated had put down a deposit to buy a home and had a mortgage commitment because they were employed and then lost the mortgage commitment because they lost their job and lost their deposit on the home, that would be consequential damages from the retaliation, but would not be wages and would not be troubled in that context.
Would that constitute the other benefits of the statute, lost wages and other benefits that are mandatory?
I don't think it would constitute benefits. I think benefits would constitute health insurance benefits, perhaps 401k contributions and the like. I would view those consequential damages as the damages section. 150 talks about injunctive relief, damages, and lost wages and benefits. And the example I just gave, I think, would fall into the category of just damages.
Which would not be troubled.
Which would not be troubled. Which would not be troubled.
Can we just,
I was just looking at the special, the jury verdict form, and I'm looking at question 9. What is the amount of money that would fairly compensate Ms. Parker for violation of the Wage Act? Why isn't that the answer? So you treble that.
Well, that is one part of it. The other part of it is question 5. Question 5 talks
yeah,
about...
but they have that same number. That's the amount due on April 1, right?
That's right.
And then question 7 tells you the $349 for the implied covenant of good faith and fair dealing. I just don't get why it shouldn't just be the amount that was the 25.
I would direct the Justice Budd to question 19. So question 19 follows a series of questions about retaliation, and question 19 asks what amount will fairly compensate Ms. Parker for unpaid Eaton contract commissions that she lost because of her unlawful retaliation. And unlawful retaliation in this case included retaliation because she was complaining and concerned about whether or not she was going to be paid her commissions. So even the trial court made it clear that the jury found that these were retaliation damages. The trial judge, Salinger, struggled with whether or not they were due and payable on her last day of employment. And I submit that that's not what the statute focuses on. That language is not included anywhere in any of the statutory sections, and respectfully submit that that should not be the interpretation.
The Attorney General, of course, seems to have the concept of special contract.
Well, what they're saying is that if an employer is allowed to hold back commissions and pay them at some point in the future, and then terminates the employee or makes that a condition of payment, that would constitute, in a situation like this, as a special contract, specifically deemed to be unlawful under Section 148.
Yeah, I can't tell whether that's your argument or not.
I'm sorry?
I can't tell whether that's also your argument.
It is. We haven't focused on the in-your-seat argument, but that's exactly what happened. In this case, it's a little bit different. They had two things. First of all, the termination for convenience was something not within the employer's control, but the second thing that was in the employer's control was that she had to be employed. The employer is the only one there that prevented her from being in her seat at the time that this commission became due and payable.
Could you help me with a simple analogy, which is not your case?
Sure.
If if there was an employee who wasn't paid for 2 weeks, a Wage Act violation established, and then the employee complains to the manager and says, listen, you didn't pay me for 2 weeks, I might go to the Attorney General. And then the manager says, okay, you want to do that? I'm going to put you on a different shift where you're not going to make enough money, and they retaliate in that fashion. Case goes to trial. There's damages for the 2 weeks that weren't paid. Everybody agrees those are trebled, correct? Attorney's fees.
Right.
The shift change, retaliation. What do you say about whether those damages are trebled under your scenario?
Absolutely, because it's a consequence of that employee complaining about not getting paid their wages. It's a retaliation. It's the same thing as a one of the cases talk about it, as a demotion. If they get demoted at a lower pay, if it's a function, if you convince the jury that it's causally related to the complaint, that's retaliation. And I think under the statutory scheme and under it's got to be trouble.
I guess that's what we seem to be trying to get at. Let's just assume that your client was entitled to these retaliatory damages, that she would have earned that money, the true-up money, and she's entitled to it. But the issue is whether it's trebled and its wages, because Eaton hadn't even made it, separate and distinct with what's going on with Ms. Parker. Eaton just hadn't made a decision yet about whether to exercise the termination for convenience clause. So assume you have the damages. I guess since Eaton hadn't made a decision yet, why would those be damages that would be trebled?
Sure.
That's what we're struggling with, I
Okay,
think.
sure. And the reason for that is because those damages would have been paid on or about April 1st of 2016.
So
And
you're
they weren't paid.
assuming that they would have gone forward with everything in your...
Yes, if Eaton was, Internoc was found to have owed that money, so they would have been paid, and so they would have been paid prior to the trial, and so therefore they're akin to back wages. And again, I respectfully submit, there's nowhere in the statute that focuses specifically on what amounts are due on the last day of employment. They talk about damages as a result of the retaliatory conduct.
Okay, thank you.
Thank you. I'll rest on, in terms of the issue about the true-up policy, we'll rest on the brief. Thank you.
Thank you. Mr. Schroeder.
Thank you. Good morning, Justice of the Supreme Judicial Court. It's Donald Schroeder. I'm here with Aaron Horton from my firm. I think one thing is clear. You start with this. There are two statutory hurdles to the claims by Ms. Parker and the Attorney General's office with respect to the idea of whether or not treble damages would be applicable in the context of retaliatory conduct. You start with the first hurdle. The first hurdle is the Wage Act as it's written. Under Section 150, there's three types of remedies: injunctive relief, damages incurred, lost wages, and other benefits. But only the second sentence relates to treble damages, where it states only for any lost wages and other benefits.
Now, there's no dispute about that, is there?
There's no dispute about that, but I think then you go to the issue of legislative intent and what the legislature did, because this isn't a case where we're looking back at a law or the legislature's thinking 50 years ago. It was just 11 years ago in 2008. And what did the legislature's final version state or reflect? It changed may to shall for when treble damages would be mandatory. And two, it took the 1993 version of the act relating to the private right of action and broke it into two sentences to reflect the limited circumstances when treble damages would be available.
That was true before the 2015 amendment, wasn't it?
No, actually, the 2008 amendment is where it was broken out into two sentences.
2008, okay.
And so the 2008 amendment breaks it out so that instead of just one sentence that included treble damages and then lost wages, et cetera, in 2008 it broke it out into two sentences so that there are three types of civil remedies, and then below that there's a separate sentence relating to just treble damages and when treble damages would apply.
Yes, that's true, but that's undisputed.
I think it goes to the legislative intent as to
Well, what is the legislative intent? Did they ever define what lost wages mean?
Well, I think it goes to what the legislature was doing here, because what the legislature, Justice Lange, was doing here was deciding that they were going to say shall be treble damages
Yes.
in only one circumstance.
Lost wages.
Lost wages and
But they didn't
benefits.
define what lost wages were.
They did not define what lost
So
wages were.
we don't know if they are lost wages under the 149, I'm sorry, 148, or under retaliatory damages. They never said what it was.
That's true, except that when you look at the statute, it doesn't include other damages incurred. And our position is that retaliation damages are in that category of other damages incurred. In fact, it goes to Chief Justice Gantz's point about the fact that, well, what would happen at the end of the day? You'd have retaliation damages, and what would you have to do then? Some might be lost wages, some might not be lost wages. How would you determine that?
Jury questions.
Well, I think it goes more to what the legislature says, respectfully, Justice Lank. I think it goes to the issue of other damages incurred not being within the context of where treble damages would apply. The statute's unambiguous.
What would constitute other damages then?
I'm sorry?
What would constitute other damages?
Well, other
You're
damages
saying
could be retaliatory damages.
Okay, but is that the entire category? What else would be there?
Well, any kind of compensatory damages, any emotional distress damages, any other front pay, back pay, anything else would be in that category of other damages incurred. And I think
Back pay would be too?
yes, yes. Well, I think it goes to the issue of the Calixto decision when you get to the point of Calixto where this court held that back pay are not earned wages. I think the argument was made by the Attorney General's office that you should have a situation where retaliation damages equals back pay and therefore it equals lost wages. Well, that's contrary to Calixto, which talks about the fact that you're talking about WARN Act and whether or not compensatory compensation to compensatory damages to employees is covered under the WARN Act, and whether or not
Calixto wasn't back pay, though. It was,
Oh.
Warren Act damages are different than back pay, right?
Understood. But I think the point of the one point from that ruling, Justice Kafker, was that earned wages are not the equivalent of back pay, and quote, back pay is not the same as wages earned, but not paid under the Wage Act, which has its own particular and precise requirements.
But the cases that it relied on explicitly recognize that it does not have any applicability to wages that take the form of commission payments. Isn't that true?
I'm sorry?
The cases that Calixto relies upon makes it very clear that it doesn't have any application to commission payments.
No, but then if you go to the second hurdle, so I think the first hurdle, Justice Lank, is whether or not retaliatory damages are covered under the other damages incurred within the Act and therefore not subject to treble damages. But then you get to the issue of what are we dealing with here, the retaliation damages. And we've heard mentioned by my brother of the Fortune Doctrine, mention of back pay. If the Fortune Doctrine applies, then it's a contract claim. Well, if it's a contract claim, then it's not going to be considered wages, and in fact, the court ruled under the implied covenant of good faith and fair dealing that it was in fact a contract claim. What about the issue of the second statutory hurdle that is before the plaintiff in this case? Commission is only a wage if it meets certain requirements under the statute. The Wage Act's unambiguous on the definition of commission. Commissions, and in fact, commissions are the only contingent form of compensation covered by the Wage Act. The Wage Act sets out limited circumstances in which a commission is a wage. It does not say that a commission ripens into an earned wage as work is performed, contrary to what the Attorney General submits, or that the Wage Act uses the phrase earned commission. There's no such nomenclature anywhere in the Wage Act. So what do you have at the end of the day? It's not a wage unless it meets two things: definitively determined, due, and payable. And as the Weidman versus Bradford Group holding by this court noted, it's definitively determined when the amount owed is arithmetically determinable under the terms of the commission plan.
And why would that not be the case here?
Well, why it's not the case here and why this is separate, and I'll try to answer also the special contract point that was raised. This is different from a special contract issue because here what you're dealing with is not whether or not Ms. Parker is there. And I understand, understandably, the special contract cases state, well, if it's up to the employer, if it's in the employer's control, well then that's a special contract. But here where this...
So that would be true of the notion that she had to be actively employed, contingency.
Correct.
Okay.
But here's the key contingency, Justice Lank, that exists in this case, and which is why a commission was not definitively due and payable and not definitively determined on the date of Ms. Parker's last day of employment.
Why does it have to be on that date?
Well, I would submit that the rulings by the court, in fact, if you look at the statutory language of the act with respect to commissions and the fact that it says to such employee,
It's only as long as she's an employee.
right, this
And
commission.
again, doesn't that get you into the special contract problem?
However, even if you get to the special contract issue, Your Honor, what you're dealing with then, though, in this case, which is different from all the special contract cases, is the fact that there was a contingency that was outside of the control of the employee, it was outside of the control of the employer, and or not as well. And the contingency was, they signed a contract March 4th of 2016. Ms. Parker was terminated April 1 of 2016. However, the trigger, the termination for convenience trigger, and by the way, just so the court understands, the termination for convenience language basically was a period of time where the individual or the client could decide, okay, what do I want to do here? I've got three options, really. Even though my brother's appeal briefs and the Attorney General's office leaves the impression that the contract had expired or the contract it was just extended and there was nothing that happened. If you look at the appellate record, specifically Roman numeral 2, 195, Ruggiero Branco's testimony, they were using the TFC clause as a lever to substantially renegotiate the contract. And in fact, the record reflects that it was substantially renegotiated 13 months after Ms. Parker's
All right,
termination.
but let's focus on that. What difference did it make to the arithmetic? What difference did it make to it was a $20 million contract, was it not?
No, it wasn't at the end of the day, Your Honor,
Was it?
because it was substantially renegotiated. I don't have the exact figure of
But
what
shouldn't we know that? Was there a trial
That's
testimony
the
about what
problem.
it
You
was?
couldn't. There's nothing in the record.
Well, she gave testimony, didn't she not? Did she
She
not?
did, however, and this goes to a fair point about the fact of the amount that was attributable to it.
Yeah.
There is not one document in this record that reflects, despite our best math skills, and mine may be questionable, but Ms. Horton's are top-notch. We could not find any document in the record that supports this $349,098 and
What about her
change.
testimony?
Her testimony doesn't relate to that number either. And so this goes to the fact that it was not arithmetically determinable on her last day of employment. In fact, no one knew at that point what would happen 13 months later.
Right,
No
but,
one.
but if she had not been fired, and the jury found that she had been fired for the unlawful purpose of depriving her of a commission, if she had remained there, what would she have earned in April of 2017 when they renegotiated it and did not trigger the termination for convenience clause?
Well, it was our position, Chief Justice Gantz, that there was no true-up policy. So our position all along was that she wouldn't have been entitled to any additional pay because the commission plan, as it was written, said if you have a contract with a termination for convenience clause, we are only going to pay up until the guaranteed term that you negotiated.
Okay, but upon them not exercising the termination for convenience clause, at that point, it became guaranteed for the balance of the contract, correct?
Not actually in this case, Your Honor.
Well, but had she still been working there, it would have, correct?
No, it was substantially renegotiated. So the record
When was it substantially renegotiated? What date was that?
right in, I think it was papered April 4th of 2017.
And where does that fall in the timeline of events
Well, it's
here?
right in so there's a 12-month period. It's really 13 months. There's 12 months, and then there's a 30-day window before it would become effective. And so what is in the record is the fact that this contract was substantially renegotiated in the interim. And in fact, Ruggiero Branco testifies to that on behalf of Ms. Parker, that there were a lot of problems with the contract. It gave them the opportunity and leverage to do a deal substantially different than the one that
I'm
was...
aware of that, but let's assume she had still been there. Are you saying that she would have gotten nothing for the second part of that contract had she been there as a commission?
No, she would not, because it was not a...
But the jury appears to have disagreed with you in terms of the true-up policy. I mean, you're claiming that there was not evidence sufficient to support that, and we'll have to look at the record to see if you're right. But if the jury was indeed entitled to say, no, the true-up policy existed, she would have been entitled to a second installment of her commission, correct?
Correct, under the contract claim part of it. And this ties into the questions before the jury. And even question 19 relates to the compensation contract, the commission plan contract that had been formed earlier. So this all goes back to contract damages. So yes, Your Honors, if the court agrees that the JNOV should not be upheld and that there is a true-up policy, okay, that becomes a contract claim, which is exactly what was found by the court and by Justice Salinger. And so at the end of the day, you're dealing with a contract claim as opposed to commissions, which are definitively determined due and payable at the time of termination.
Well, you've got me completely confused. Why is there a difference between a contract claim and a commission?
Well,
When the contract specifically deals with what's going to happen with a commission.
because under the Act, in order for it to be, if it's not a lost wage, if retaliation damages are not considered other damages incurred, right?
Well, that's an assumption.
Okay, that's an assumption that they're not other damages incurred, but that's one hurdle. But if you get to the second hurdle of, well, how would they be considered lost wages or wages?
Yeah.
You've got to determine whether or not this commission, and that's exactly what we're dealing with here, commission, whether or not it was definitively determined and due and payable. So you go back to what the statute says as opposed to what the contract says.
I'm sorry, go ahead. Finish it.
And so what you're left with, and I think that when you get to the issue...
That gets me, then I get confused, because the commission's due, say the commission were due the day before she was fired. How would that, say they fired her the day before, how would, in your analysis, she still wouldn't get treble damages?
No, if she was, so what happened here,
But no, just
well,
take my
it's actually the same-
hypothetical, take
it's
my
the-
hypothetical for 1 second.
Sure.
So she's gonna get paid on April 4th. They fire her on April 3rd, just to deprive her of that, a classic Graham or Fortune type of action. Does she get treble damages there?
yes.
Why does she get it there and doesn't get it in this circumstance?
Well,
That's
the
what I'm
issue
trying
is
to
if they're definitively determined and due and payable at that time. So and the only reason, Justice Kapfer, I was going to what happened in this case is Ms.
I
Park.
want to get there too, but I just want to understand, because to me I don't buy into your argument that it has to be on the last day of employment if the employer can manipulate that day. But at the same time, I believe that Calixto, or whatever it was called, stands for the proposition that we treble things that are past due. We don't treble things, because the idea is we don't like employers to take your money and take your work and not pay you. But these commissions are kind of a mixed bag here. So I'm trying to understand that hypothetical. If we'll do the next day, you say they get treble, but they don't get treble here because it's due far into the future and there are other contingencies. Is that it?
Correct. And if I may respond?
Of course.
So one of the cases that I think is really instructive on this, Justice Kapfer, first of all, Ms. Parker, there were definitively due.
But could you answer that question?
Sure.
Because I'm still confused why they get paid if it's the next day, but don't get paid if it's months down the line.
If they're definitively determined and due and payable. And so what happened with Ms. Parker is she received a $100,000 check 3 weeks after her termination for what was due and payable on the guaranteed term at that point. So that's different from a contingency that we have no idea what's going to happen down the line.
Isn't there an easier way to say that? Is it?
There might be.
Is it up to the employer on the day that she leaves whether or not that commission's available, or does some third party, Eaton, have to do something before the commission is calculable and due and payable?
Right.
Isn't that just an easier way to say it?
And that's the difference between how and what happened with Ms. Parker. What was definitively due and payable was paid to her, actually.
Actually, you
Right
were
at the-
shy by about $30,000 on that one.
Yes, the court did find it was shy of $25,000, Your Honor, and as a result, that was part of the Wage Act claim. That was definitively determined due and payable based upon their calculations. But the commission, this other unpaid commission that is part of the retaliation damages, relates to a contingency that is outside of the employer's control.
Did you ever answer Justice Gantz's question? I don't think you did, about how much would have been due and payable to her had she just remained,
Well,
and when?
we have no idea. There's nothing in the record to reflect that. But also, because the true-up policy was that, because the underlying policy, the SCP, the Sales Commission Plan, only provided for the guaranteed portion.
Forget that, forget what, because the jury found differently, forget that. I'm talking about, assuming that the jury is correct and it has a basis for what it found. The policy was in effect, you were bound by the true-up policy, let's assume that. You were bound by the true-up policy, and I want to know what would have happened had she stayed?
There's nothing in the record to reflect what that number might potentially be.
Did she not testify as to that?
No, I would submit that she is not entitled to that, because obviously this goes back to our JNOB.
Testify to that?
No, no, she did not testify to that amount that the jury awarded.
Going back to your answer to Justice Kafker's question, I want to clarify something. So the Eaton deal closed on March 4th of 2016, correct?
Yes.
What if she had been fired on March 3rd of 2016, knowing that the deal was going to be closed the next day, precisely for the purpose of depriving her of a commission? Would she get treble damages for the amount that, for what was here for what at least Enternox said was the $100,000 she was due, or would she get $300,000?
And you're saying if she was just terminated the day before purposefully for that?
They know basically the deal is going to close, we're going to owe it to her, it's going to be due and payable upon the closing of the deal, at least as to the first guaranteed part. So, and if we don't pay her that, we want to stiff her. If we don't pay her that, we know we'll have to pay treble damages if she stays on board. So let's fire her the day before. We'll have retaliation damages, and under the Parker versus Enternox decision, we'd only have to pay her $100,000 as opposed to $300,000.
I don't think this is separate and apart. So under that scenario, whether or not she did everything under the plan, that the commission was definitively determined and due and payable, well, if that was the case, she would be paid that. In fact, in this case...
But you said that she had to be on board, so that
well,
it was not due and payable on March 3rd.
But I guess the contingency that I think we were talking about with respect to the special contract issue is the contingency here was 13 months later as opposed to...
Okay, but try my question.
Okay.
Try my question. We're speaking about the first guaranteed period.
Right.
Okay? And if she had been fired on March 3rd, 2016, in a retaliatory fashion, because Enternox said, we want to stiff her on the commission, and if she stays, we'll have to pay her treble damages for stiffing her, so we're going to stiff her, we're going to fire her the day before, because that way it would only be single damages. Is that your view as to what the law is?
No, under that scenario, she'd be entitled to the lost wages, and it would be trebled.
Okay,
That's
so
different
why?
from the
But
scenario.
that's retaliatory. It would be a retaliatory firing, because the amount would not be due and payable at that point on March 3rd, because the deal hadn't closed,
Well,
correct?
It would be definitively determined and due and payable
On the next day.
right in that time frame. And so I guess the issue would be whether or not something's considered lost wages for work performance earned as opposed to something far off in the future. And I understand your point that it's happening right in that scenario, and it's happening in the date time period.
So is the difference here then, because in the chief's hypothetical, March 4th, we know exactly what's due. So it's definitely due and payable the next day. It doesn't need to be paid that day, which is, by the way, a change from our jurisprudence a little bit. But if it's due and payable 18 months from now and there are contingencies involved, then it doesn't meet this definition for treble. Is that your principle? Because we need a principle way of distinguishing these two, and I'm trying to understand it.
Sure, and I think the issue is that there was unlike which I think is akin to the special contract line of cases that Justice Gantz was getting at, where the employer decides on their own, well, you've got to be here by an arbitrary date. You've got to be here a certain date, and whether or not you're here or not, whether it's retaliation or otherwise, you're not here, we're not paying it. And I think that's akin to what Chief Justice Gantz was saying.
Well, the Enternox policy says you must be employed to earn commissions, so it's not my hypo, it's yours. It's what your employee policy declares.
Understood, but I think the other contingency which is critical here, because there's two then. There's contingency of being there, but then there's the contingency that is reality of this situation, which is 13 months later. We have no idea at that point when we do the deal whether or not Eaton's going to walk away, whether or not they're going to re-up, or they're going to do the third option, which is they're going to use it as leverage to renegotiate, which is exactly what they did. And at the time, this would leave an impossible position for Enernoc to know, well, what would we owe under that scenario? And you get back to the Mew case as far as chronology. At that point in time, we have no idea what Ms. Parker, what Eaton was going to do with respect to the underlying contract.
But it wasn't the contingency about whether or not Eaton was going to had the opportunity to renegotiate, but whether or not it was going to stick with the contract at all. It was going to engage with the TLC clause, or whatever it's called.
Well, there are three options that they had. It basically, at 13 months, they could...
But I'm talking about in terms of the true-up policy, was it really 3 options? Did they ever take the third one into consideration? That Eaton would use this as an opportunity to renegotiate?
Yes.
Was that a contingency? Was that spelled out in the true-up policy?
No, there was no... So our position is there is no... There was no
I understand
true-up
that, but I'm
policy.
saying suppose there was
No,
one.
it was not spelled out in the policy.
Okay.
Okay, thank you.
Thank you. Thank you very much.